Okay, so here we are at Hotel 17 on 17th Street between 3rd and 2nd. And we're going to visit our friends who've come up from South Carolina, Rod Class, he and his wife. So let's see what we learn here. And there's Joe waiting for the elevator. Kind of a nice look, a European elevator. Welcome to New York, Rod.
Oh, thank you. Thank you.
Now, I heard you've had some interesting things happening with Raja, the forensic examiner, who our viewers are familiar with. Can you say what you and Raja were doing?
Yes, him and I was involved in a case over in Cincinnati, Ohio. The couple was forced into foreclosure. And what we did, we took them into a bankruptcy court. And while we were doing that, the couple had to hire an attorney to go into federal court. I went in several weeks prior to Roger showing up. We talked to the attorney. We laid out the bankruptcy of the United States. And that's what everybody doesn't understand. They don't understand the 1933 bankruptcy and how significant it is. Because once you get into Title 12, and what's Title 12? Bank and banking laws. Once you get into the banking laws and you get into Section 95, 95A, 95B, and get into Section 411, that goes in and shows and declares the state of emergency. There is no money, there's no gold, there's no silver. It is the obligation of the United States. And the Federal Reserve note is supposed to stay within the Federal Reserve system. It's not supposed to come out to the people. So what we did, I laid out the entire bankruptcy of 1933 to the attorney. I sit in and showed him where Lindbergh from 1917 went back in and addressed the bankruptcy of the Civil War. We went into McFadden's 1932, where he came in on the floor of Congress and sat here and stated that the Federal Reserve notes was not money, but a mere promise to pay. Now, ladies and gentlemen, this is not me saying it. These are congressional records, and that's what we pull back up. So when we handed this out to the attorney, I do the legal side. I do the law side. I bring in the statutory, bring in the congressional side of this thing. So when we lay it out, the attorney turned around 3 days later, told his clients that I did not tell them anything that they as the attorney, they as judges, already did not know about the bankruptcy. So we brought in the proof of the fraud that all mortgages are securitized. Well, Raja brought in the securitization from the
Forensic examination?
He brought in the securitization from the Security Exchange Commission. He did the background on it. It sits there and shows that whenever you sign your name on a mortgage note or a loan or a Visa card, that signature is securitized because the banks are not giving you any money. They are giving you credit, and they're securitizing off of your signature. This is what McFadden was talking about in 1932. This is where he has a whole list of congressional records, about 4 pages, that goes in and shows about your signature being securitized. Well, this is what Roger got into. So when we put this before this lawyer in Cincinnati, Ohio, the first thing he wanted to do was resign because he could not represent Carl and Vera in the courtroom, because if he was to come in and says, Your Honor, the clients here have evidence of the bankruptcy of the 1933, the banks are not lending any money, they're lending credit, he would be disbarred. So when we got into the court that day, Roger and I both showed up. We was not supposed to be there. Our summonses never came out to us. Our subpoenas never came out to us. They withheld them. We showed up anyhow.
How did you know to be there if you didn't get a summons? How did you know what was happening?
We had contact with Carl and Vera, and we told them.
Oh, the client.
The client. We told them we would be there regardless. See, I came in as a private attorney general. I came in as a PAG. All right, I hold position through the United States Congress. All of you hold the ability as a private attorney general through the United States Congress. Congress passed a law in 1866. They turned around and passed it again in 1979. All you have to do is understand the rules, the regulations, the statutes, the codes on their side, because it's their procedures. Once you understand it, you can walk into the courts and you can debate them. So when we walked into court that day, I was all dressed up and I was ready to do my part as a PAG. The attorneys came in for the other side. We all walked up to the judge and they sit here and asked the judge, says, Mr. Class is here to help represent the defendants here, or actually the plaintiffs here. And she says, well, Mr. Class, are you a bar card holder? I says, no, I've got congressional jurisdiction. She said, you want to see my credentials? And I laid my credentials out, and I sit here and showed her, said, you see where it says stamp by the Judiciary Committee on the House and Senate side? You want to see the federal law says I can? Her mouth dropped, and so did the attorneys, because they thought I was bluffing. They didn't realize I had congressional documentation. And I reminded that judge, I says, you see that sign that's sitting behind you? And she says, yes. I says, you see where it says District Court of Ohio? And she says, yes. I says, you are an Article 3 court under the Judiciary Act of 1789. The statutes at large. You're under the revised statutes. You are under the Judiciary Act of 1911. And you're also under Title 28, which is the Judicial Procedures. Your procedure says you're an Article 3 court. And she looked at me and she said, you're not the bar card attorney, are you? I says, no, I'm not. She says, well, they already got an attorney and we're not going to allow you to represent them in here. So we all sat back and the attorneys popped up and said, well, Mr. Klaus is still sitting within the bar. And she asked Rob if he would like to have a few minutes with me, because he sits here and says, look.
Excuse me, who's Rob?
Rob is the attorney for Carl and Vera.
Okay.
He's their attorney. And he says, I need Mr. Klaus's assistance to get the point across of what my clients are trying to iterate on their case. He says, because I cannot present their case. Mr. Klaus can.
As a private attorney general.
As a private attorney general. I can't.
And you had the credentials for
I
Congress.
got the credentials to do it.
Wow.
So she gave us a 15-minute recess. So when we came back in, I was not allowed to cross the bar. I had to stay out in the site. So Rob, the attorney, he went up before the judge and he pleaded and he begged with the judge, and we got on transcripts. 4 times he sat here and explained to the judge, says, Your Honor, I cannot represent my clients. Because if I represent them, it is in conflict with my rules to the court and my oath to this court and my duties to the court. I cannot represent them in the means that they wanted represented. And the judge looked at him and says, are you telling me, is this your choice or is this your client's? He sat down and says, I cannot represent them because they know if I do, I could be disbarred. She says, you will be disbarred under Rule 11. She warned him twice.
Can you tell us Rule 11?
Rule 11 is where the attorneys have to comply with their oath to the court, not to the client. And if they sit here and violate, they can be disbarred from practicing law. So we got an open record and a transcript where the judge threatened him twice with Rule 11 of disbarment, because if he tried to bring in the bankruptcy of 1933 and bring in the proof of the securitization of what the banks did on this, he would be disbarred. So whenever he got done talking, the attorneys for the bank showed up and said, Your Honor, because of the conflict that we have with the plaintiffs over here, with Carl and Vera, and their knowledge, no lawyer will ever take their case, and they'll never get a law firm to represent them. Because of how they're proceeding with this, they can never be represented by lawyers. So the judge threw me out got rid of the attorney. The bank came in and says they can't be represented because they can't expose the truth. So this is what we're running into. This is how Roger and I, with what Roger done, I bring in the laws. I show you where the congressional laws are at. Roger brings in the paperwork from the Security Exchange Commission. And when he shows when Bank A sold it to Bank B, and Bank B sold it to Bank C, and Bank C sold it right down the line, how much money they made off of this, this is the proof of the bankruptcy. It's all securitization. See, what people aren't aware of when they're securitizing this is that they're not paying off the public debt. This is where the problem's coming in. They're embezzling the public debt. So if they were to do it right, the public debt would not be some $15 trillion. It would be zero, because they would be paying off the public debt because there's no money. And see, this is where the congressional records are so important. This is why I do the research in congressional records. It's like the attorney sitting here and said, well, Mr. Glass, these are not laws. I said, you're absolutely right. They're not laws. What it is the intent of the law. And when you have the intent of the law, it tells you what the law is supposed to be and how it is supposed to be written. And if you get into Title 12 under the Code of Federal Regulations and get into Chapter 9, 9.1, now the Code of Federal Regulations is the next step down from the Federal Registry in the laws. You have what is called a House Resolution. Then it goes into public law. Then it goes into the Federal Registry. Then it comes down to the Code of Federal Regulations. And from there it is deciphered down to the United States Code. So when you get into Title 12, which is the Bank and Banking, Chapter 9, under that 9.1, 9.2, it refers you back to Title 12 USC Code 95A, 95B of the bankruptcy of the United States. There's no money. And this is what we're coming back in and exposing. And this is what the courts do not want exposed. But see, everything I deal with their own rule books. I deal with their own regulations. So when you're bringing it in and you're showing, aren't these your laws? Did you not create these? Aren't these your rules? Aren't these your regulations? Because under Title 12, that 95 is banking duties and regulations. What is the regulations? What's duties? It's their obligation. So when you point out,
obligation to you as we the people?
It's an obligation to we the people. So when it says plainly in their own set of rules that there's no gold, no silver, and that we're under bankruptcy, and it takes you back to that March 3rd, 1933, and it takes you back under that Public Law 1, 48 Stat 1, which is better known as H.R. 1491. This is that state of emergency clause. It shows that there's no money because it shows if you had any gold or silver, it shows that you were placed under a penalty of a $10,000 fine and 10 years in jail for having gold and silver. So this is what we're coming back in and addressing. The courts don't want to address the bankruptcy, but it's like I told Carl, so stop and think here for a minute. And I said the same thing I talked with Raja. We're walking into a bankruptcy court, are we not? What's a bankruptcy court? Bankruptcy court is to hear bankruptcy.
Right.
And if we're going to talk about bankruptcy, it isn't the people that are bankrupt, it's the banks that are bankrupt.
Right, asking the people for more money.
Yes.
So we're the creditors. You come in as a creditor. Huh?
It's the federal government that is bankrupt. It's the Treasury that is bankrupt. It is not the American people. It's the system. And the bankruptcy court don't want to operate and don't want to address the bankruptcy of its own system. They want to put the burden onto the people.
Right, and it just keeps...
And that's what we're trying to get into the securitization with Raja. This is one segment. The other segment we're going to get into for this program is the corruption of the court system. They just passed a public law 112-63. What this gets into, what it explains, is the jurisdiction and venue clarification of the federal courts. What they have come back in and stated is what we've been teaching all along. When you're going into the United States District Court, that United States District Court is an IRS court. That United States District Court is a bankruptcy court. That United States District Court, it falls under foreign sovereign immunity. It falls under Title 28, that 1391. That foreign sovereign immunity is a foreign state court. This is for dealing with alien residents. And that's how they have the American people classified. See, all this falls back under the bankruptcy of 1933. Because if you look at and you get into the Public Law 1, 48 Stat 1, and you get into the state of emergency, it deals with the Trading with the Enemy Act of October 6, 1917. Go back and read this. And it shows that it made the American people alien residents, alien enemies of the state. And all you have to do is go back in, look under Title 50, get into Chapter 3 for alien residents, get into Section 23. It says jurisdiction of the courts and judges. And it gets in and classifies the criminal aspect. And this is where criminal charges comes in. And they're dragging you and I in under alien residents as an alien enemy resident. So when they
How did they sell the people on that in 1917?
What they did in 1917, that's when World War I came out. All right, remember, the Federal Reserve came in 1912, 1913. Whenever Germany wanted to create a war in 1917, the Federal Reserve went over and sat down and says, okay, you want to create a war, you use our currency, not yours. So what they did is they took over their German money, gave them Federal Reserve notes so they can sit here and buy and sell and trade. So this way the Federal Reserve can make profit on both sides of the fence. This is how they did it. Well, it worked so well that in 1933 they passed what is known as the Mandatory Act here in the United States, where they made the people the enemy of the state.
In 1913?
1933.
Or 33.
1933. That's when they did the bankruptcy. That's where the state of emergency comes in. See, nobody was teaching. Most people understand HJR 192, which was Public Law 10, Chapter 48 Stat 112. That's where they came in. They took the gold and silver off the people. But they took the gold and silver off the people after they passed the state of emergency clause. They did the state of emergency first, put you as an enemy of the state under the Trading with the Enemy Act. Then they came in and confiscated our money. We now got occupied, and we was never aware of this. See, nobody teaches this side. I do. And
surely people who had to give up their gold were upset. They felt probably ripped off.
Well, see, they did, but see, the problem of it is, what people were not told, that's where McFadden comes in 1932. He sits here and shows where the Federal Reserve embezzled $113 billion in gold bullion out of this country. And guess where it went? Went to Germany in 1939 for Hitler to start the war.
Wow, never heard
This
that
is all
one.
documented in congressional records. This is why this is so important. This is why we bring this stuff up, because it can all be validated through
This is
congressional
incredible.
records.
It's like our media doesn't give us a clue of
Well, they
what's
don't.
really going on in Congress.
This is all hidden. This has all been tucked away.
So I understand you and Raja would go down to D.C. and go to Congress.
We have. We've been down there.
That's how you find this out?
Well, no, I found this out way before that. What we did is when we was up in Maryland, Raja, Jeff, and Carl Weston, and a few people from the seminar we had, we went down to D.C. We showed them how to lobby Congress, how to deal with the corruption of the courts. And what we brought into the legislation is I sit down and says, look, I said, we got a very serious problem here. We need to address the bankruptcy of 1933. You should have seen the people came out of the back room. They didn't want their front office clerk hearing this.
Yeah.
We rattled their cage. We hit a point. We went back and we addressed the fact that they did the Trading with the Enemy Act on American people under the Mandatory Act of 1933. Show where they brought the 1917 Trading with the Enemy Act, brought into 1933. We showed where they did all this. These people came out of the woodwork to shut us up. We got out in the hallway and we talked to several different gentlemen, and they flat out told us, we got hold of the Ways and Means Committee, not the congressman, but his aide. And we explained this to him. He says, I want to tell you what, it is about time you people start walking into Congress and laying down congressional records that back up the corruption of the system.
You know, Rod, at the deed office here in New York City, I had some people who work in the deed office saying, it's about time. It was the Rob Ryder stuff that I did.
But see, everything I tell people, and my whole philosophy is, if we're going to do the paperwork, make sure you got the black ink on white paper. Make sure when you walk in, like we walk into bankruptcy court, we're bringing in Title 12, banking laws, 95, 95A, 95B, Section 411. The obligation of the Federal Reserve Note goes right back into the United States. It don't belong to the people. So when you're bringing in their own statutes, you're bringing in their own regulations, they can't argue with their own black ink on white paper. They try to throw it out as frivolous, unintelligible, incomprehensible, but now your objection comes back in. Are you telling me that you're not capable of understanding your own rules and regulations, that it's that frivolous? If it's frivolous, then you don't have a job here sitting on the bench as a judge, because that means you're incapable of understanding your own rules and regulations.
Now, their own rules and regulations, is that a way of keeping another monopoly from coming along and doing what they're doing?
Well, this is part of it. They don't want any of this brought in.
Okay.
They don't want it brought in. Because, see, the lawyers...
They've got a good scam going.
Yes. This is why Rob, when he tried to bring it into the court in Cincinnati...
Excuse me, now Rob was the attorney
for your
attorney
clients. For Carl and Vera.
And he was a member of the bar.
Yeah.
Right.
And the judge threatened him with disbarment if he would bring in the truth. No lawyer can bring the truth into a courtroom. This is why I try to teach to people why we're doing AIB radio. We do it 2 nights a week on Tuesdays and Fridays, to where we get the people to download, understand the laws, understand your rules, go in and defend yourself, because no attorney can come in and bring any of this information in, because he's a bar member. He can't expose to fraud. He can't expose to corruption. We can. And this is what upsets them. This is one of the reasons why they passed this new clarification in the federal court. But what they turned around and admitted is that they're bringing it in under foreign state. They admitted that they're bringing it in under alien residents.
They admitted you had
They admitted it's the clarification. What this is, now this isn't a new law. This is a clarification of an old law. Now stop and think. Clarification of the old law? What they're sitting here saying, that every single person who's ever been brought before a federal court in the United States District Court has been tried wrong. They brought them in under foreign sovereign immunity. They brought them in where they had to go through the Department of State. They had to get a waiver. They never did any of this.
Never went to the State Department.
That's exactly right. And this is part of it, because when you're going into the foreign sovereign immunity side, what this is like China suing the United States. You've got to get permission. You've got to get their immunity waivers. Okay, the attorneys, with this new law that they just passed for clarification, this means that every single attorney that's ever misrepresented anybody in federal court is now liable for a lawsuit for misrepresentation. Because when they brought you into the United States District Court, they brought you into a foreign sovereign immunity court, or they brought you into a territorial court. And this is where we are teaching how to go into the District Court of the United States, because that District Court does exist. Because when we got into their rule books, you get into Title 28, get into Section 610, it tells you Court of Appeals, District Court of the United States, lower DC, capital US, Then it gets into the capital U.S. District Court for Guam. So the United States District Court is a territorial court as well as a foreign sovereign immunity court, and they brought everybody into the wrong court. And we have now been able to prove it.
So you're saying that as natural-born Americans, we have a certain immunity from this foreign entity?
Yeah. Okay, now let me give you just a quick breakdown here. Go back into the Act of 1871. That is when the District of Columbia was created, right? Okay, that was Washington and Georgetown. That was part of the United States at one time. When they passed the Act of 1871, they created the District of Columbia. When they created the District of Columbia, they took it out of the United States of America and they made it a territory. So when they made it a territory, all laws have to come under the District of Columbia, not the United States of America. This is one of the reasons why I want to run for President of the United States. That's why we're doing a write-in for me, in order to get me in so we can come back in and fix the problem. We don't need changes.
Class,
Rodney
right?
Dale Class has to be my full name. Rodney Dale Class.
RODNEYDALECLASS.
Correct. And this is why, because we need to fix the problem. We need to put this country back into the people's hands. We need to dissolve the District of Columbia, take it out of the jurisdiction, and make it part of the United States of America again. Because, see, all these courts are charging us wrong. Because when you get dealing with IRS, what do they charge you under? United States of America. That doesn't exist.
Oh, okay.
It doesn't exist. Why? Because of the Act of 1871. Because they dissolved the United States of America. They turned it into the District of Columbia. And see, nobody's caught this.
Your research team actually went to Delaware and found out it was a Delaware corporation
Yes,
that
it is.
did not register in all the other states, so it's also illegal for that reason?
It's also illegal for that reason, but it's the fact in 1871 when they dissolved the United States and created the District of Columbia, because like I said, you remember Washington Town and Georgetown, that was part of Virginia and Maryland, correct?
Mm-hmm.
So when they did the District of Columbia, they made it a territory. What's a territory? It's not part of the United States. It is an subsidiary. So our capital is a territory. It's not the United States of America. It's the District of Columbia. They're bringing all the wrong charges into the wrong area, into these courts. The lawyers know it. The judges know it. We now know it. And this is what we're pushing. We've got to get the people to wake up.
So as president, what can you do? Because you say you can fix the problem.
Well, very simple. Remember, we're under that state of emergency clause. We don't need executive orders. We need general orders. A general order, because of the state of emergency, will allow the President of the United States to use the military to come in and to get rid of the garbage and get rid of the corruption that we're dealing with. Kennedy was on the right track, but he left the corruption in office when he took over. Everybody wants to run under executive order. First thing I would do is run under general order. I'd bring the military in. We would clean up. We would dissolve the corporation, and we'd put things back into the people's hands. This is where part of the county assembly, what we talked about here on some of the shows, but the county assemblies have to be set up right. It has to be put back into the people's hands. See, the grand jury that they've talked about and some of this stuff, a grand jury only has one function. A grand jury is to hear if there's enough evidence to warrant a trial. It's like what they did here with Obama. Federal court down in Georgia tried to charge him. They couldn't charge him because he was never impeached. They didn't follow protocol. That's the number one problem. I teach protocol. I'll show you what protocol is. You have to go through the Senate manual. It's like the Jefferson's manual. Jefferson's manual deals with the House. Senate manual deals with the Senate, and it deals with the President. It's what his job is. That's exactly what it is.
That's wonderful, Rod. So let's see what the New York audience has to say, and we'll be taking calls.
Okay, thank you.
You.